Oh, yeah, right up front. Well, let's, I thank Bob for coming in. Bob has been, let's see, has been the Vestal Coalition for more than 3 years. He's a non-voting member of the steering committee and has been instrumental in conjunction with the steering committee members in drafting their very important comprehensive landowner-friendly coalition gas leases. So, Bob, you got half an hour, so we'll turn it over to you.
Thank you, Supervisor. Everybody hear me okay?
No.
No? Okay, hear me now?
Yep.
Okay. I said thank you to the supervisor and good evening to the board members and all the visitors and guests here tonight. As Mr. Schaefer said, my name's Robert Wedlake. I'm a lawyer. I work with Hinman, Howard & Cattell, which is a law firm here in the Binghamton area. I've been practicing law for 34 years here in the Binghamton area. My practice has been a mixture of commercial litigation and other litigation representing business clients. And in the last 4 years, I've concentrated in the real estate area, particularly the oil and gas leasing. As Mr. Schaefer said, I'm the attorney for the Vestal Gas Coalition. I think the board understands that the Vestal Gas Coalition is a conglomerate of landowners and that the goal of the coalition is to secure a gas lease for the residents of the town of Vestal that are in the coalition, a gas lease with appropriate protections to protect our water, our resources, and our land. I wasn't here for Mr. Sladdy's presentation, but I had an opportunity to view it. And my purpose tonight is not to stand up here and give you a speech about the positive attributes of gas drilling and all the positive things it can be for the town, including not without limitation the millions of dollars that the town might be able to secure from the ad valorem tax. My purpose and my focus will be specifically to give the board the counter argument, the counter speech from Mr. Sladdy's presentation. To review very quickly, Mr. Sladdy made a presentation to the board on January 23rd and advised the board that the board could legally pass a moratorium banning gas drilling in the town of Vestal. Mr. Sladdy also indicated in his presentation that the town later on, if they so decided would be able to legally pass a zoning ordinance permanently banning gas drilling in the town of Vestal. Mr. Sladdy went on to say that if the town were to pass a moratorium now, that the risk to the town would be fairly minimal, that the town would not be exposing itself to a lot of claims, except for a claim similar to the claim that's now going on in the town of Middlefield and the town of Dryden. Most of you are aware that there's two lawsuits that are currently pending. One by an operator up in Dryden, which I believe is Tompkins County, where the operator is trying to declare a moratorium as illegal. And the second one is a lawsuit that's been brought by a landowner, a farmer up in the town of Middlefield, who is seeking to have the town of Middlefield moratorium declared illegal. Mr. Sladdy's theory is that although he concedes that the state law, the current state law, preempts a town from regulating gas drilling activity, that preemption against regulation does not extend to a complete prohibition. So his theory is, though, although it's clear, and he concedes this, that a town cannot regulate the operations of gas drilling, that a town can prohibit completely any gas drilling, and he submitted to the town board that this was legal, and that therefore you can impose these various moratoriums. Mr. Sladdy went through a lot of what he bases his theory on. And a lot of what he bases his theory on is the mining law, which I'm going to talk about in a few minutes. The mining law, which extends or covers, if you will, sand and gravel, the sand and gravel or the bluestone kind of quarries. He looks at what the law is with the mining law, and then he says, well, the courts are probably going to do the same thing with the gas law that they did with the mining law, and allow a town to totally, using its zoning power under what we call the home rule law, he believes that the courts will sustain a town's ability to use the zoning power to regulate its land and to zone out completely drilling. And I'm going to explain to you tonight why I feel and why I believe the law is not going to say that, and that Mr. Slotty's opinion is misplaced. First of all, we all are aware that New York State has a specific section of the law that deals with gas drilling. It's called Article 3 of the Environmental Conservation Law. Mr. Slotty, I think, read you or had a PowerPoint showing you the law, and I've given a handout to the town board where I've put forth a lot of these specific sections. I'm going to quote some sections of the law and some case law for you, and that's all in your handout so that you can look at it later. Section 230303, subsection 2 of the Environmental Conservation Law is the law that deals with this preemption or this superseding concept. What it says, and I'm going to quote from the law, it says, "The provisions of this article shall supersede all local laws or ordinances relating to the regulation of the oil, gas, and solution mining industries, but shall not supersede local government jurisdiction over local roads or the rights of local governments under the real property tax law." So that's what the law says, and what Mr. Slotty said is, well, yeah, it's true that the towns can't do anything in terms of regulation, but that doesn't mean that they can't totally prohibit. Here's what the legal analysis is with respect to his position. You have to look at several aspects of the New York State law to get a complete and accurate picture, to arrive at a conclusion as to what a town can and cannot do. And as I think you'll see as I go through this, Mr. Slotty didn't really take a look at the complete picture. Because of that, he arrived at an erroneous conclusion with respect to his advice to the town board, that the town board would be able to legally pass either a temporary moratorium or a permanent ordinance later on. The first thing that we have to look at is what is the source of a town in terms of its authority to pass laws. Did you ever stop and think how a town board has any authority, or what authority, where does it get its authority to pass local laws? Well, it's primarily from the New York State Constitution. The New York State Constitution in Article 9, Section 2C, subsection 2 states, and again I'm going to quote, it says, "Every local government," that's of course including the town of Vestal, "every local government shall have power to adopt and amend local laws not inconsistent with the provisions of this Constitution or any general law relating to the following subjects, whether or not they relate to the property affairs or government of such local government, except to the extent that the legislature shall restrict the adoption of such a local law relating to other than the property affairs or government of such local government." Now that's a mouthful, but when you boil it down and if you put it in reduce it down, there's a couple of propositions. Number one, a town board cannot pass a law that's in conflict with or inconsistent with either the state constitution or with a specific law that's been passed by the state legislature. And secondly, the state can reserve to itself or can preempt a certain area, and if the state does that, then a local town cannot pass laws in the area where the state has reserved to it the preemption of that particular subject matter. Now, you also then have to go to the law that deals with this preemption concept. Preemption is not an easy concept. Now remember what Mr. Slotty is saying, well, it's not preempted. Regulation is preempted, but prohibition is not preempted. Well, I would submit to you when you look at it, you'll realize that in effect, for several different reasons, that there is a preemption here where the state has preempted the towns with respect to banning gas drilling. Number one, I would submit to you that a prohibition is the ultimate regulation. That is, stopping an activity altogether is the ultimate in regulation. Secondly, we have to look at what's called conflict preemption, which is a difficult concept, but it has to do with it. You remember I quoted you from the Constitution that the local towns cannot pass any laws that will be inconsistent either with the provisions of the Constitution or with laws passed by the state of New York. Conflict preemption has been dealt with by the Court of Appeals, which incidentally, as you know, is the highest court in the state of New York. And in the case of New York State Club Association, and again, I have this set forth in my memorandum, the court held that a local government may not exercise its police power, which is zoning is included in the police power, by adopting a local law inconsistent with constitutional or general law. The court went on to explain that the legislative intent to preempt need not be expressed. It is enough that the legislature has impliedly evinced its desire to do so, and that desire may be inferred from a declaration of state policy by the legislature or from the legislative enactment of a comprehensive and detailed regulatory scheme in a particular area. So the exemption doesn't have to say that in the state law that a town is preempted from passing any zoning ordinance. It's sufficient. It's sufficient if there is a stated state policy and a detailed regulatory scheme. And if you have those factors present, then you could have conflict preemption where the local town ordinance on zoning would be preempted. In our situation, let's take a look with what we have. In Article 23 of the Environmental Conservation Law, the legislature set forth the state policy. The state policy and state purpose, as announced by the state legislatures, is as follows. It's hereby declared to be in the public interest to regulate the development, production, and utilization of natural resources of oil and gas in this state in such a manner as will prevent waste, to authorize and to provide for the operation and development of oil and gas properties in such a manner that a greater ultimate recovery of oil and gas may be had, and that the correlative rights of all owners and the rights of all persons, including landowners and the general public, may be fully protected. Now, again, that's a mouthful, but I want to take that apart for you, and I'll explain some of these items. So that's what the state policy is. Now, Mr. Slotty would probably say, well, that doesn't say that it's a state policy to be sure that we can develop gas, and there's nothing in there that says we can't completely prohibit it. I would submit to you that's not the case. How on earth can we regulate gas in such a manner that a greater ultimate recovery of gas may be had if we prohibit it? It's impossible. You can't advance one of the state policies of having a greater development of natural gas if you're prohibiting it. It's just completely inconsistent. Furthermore, this section also says, or the state policy says, that the correlative right of landowners shall be protected. Now you may say, what the heck is correlative rights? Well, I can tell you what correlative rights are. Correlative rights means the rights of landowners to enjoy their mineral resources. When I say enjoy their mineral resources, what it means is the right of a landowner to lease or to develop and to sell his or her gas and to receive the proceeds from that. That's one of the property rights that a landowner has. Right in here in the state policy, it's clear that part of the state policy is to protect the correlative rights. A total prohibition against gas development is completely the opposite. It's completely inimical to the protection of correlative rights. Therefore, I submit to you that it is clear that unlike the mining law, which I'll get to in just a minute, the state policy with gas development is to facilitate gas development. Aside from that, now remember I'm going to go back to the conflict preemption. That says that the state either has to have a stated state policy or a regulatory framework. For those of you who are not familiar, Article 23 is a very comprehensive regulatory section. Sets forth all aspects of how the state is going to regulate the production of gas. So under the conflict preemption tests, under both the state policy and whether or not the state has a regulatory framework, under both of those tests, a prohibition of gas flunks. It fails those tests. Therefore, I submit to you that there is more than a likely possibility that when this issue is decided by the highest court of the state of New York, which is the Court of Appeals, that the state court will find that the moratoriums are illegal. You know, a lot of what Mr. Salati was basing his theory on is the mining law, as I indicated to you before, sand and gravel. And what he was looking at was an old case that held that even though there was a state law that said that the towns cannot regulate sand and gravel mining, that they still could zone out sand and gravel. That old case was then changed by a change in the New York State law. And in 1991, the New York State law on sand and gravel and extractive mining was modified. I'm going to read to you that section, okay? It's section, again, it's in Article 23 of the Environmental Conservation Law. It's section 23-2703, subsection 2, subsection B. Now remember, this is sand and gravel, okay? What this says is that for the purposes stated herein, this title shall supersede all other state and local laws relating to the extractive mining industry, provided, however, that nothing in this title shall be construed to prevent any local government from enacting or enforcing local zoning ordinances or laws which determine permissible uses in zoning districts. I'm going to repeat that. Enacting or enforcing local zoning ordinances or laws which determine permissible uses in zoning districts. So in 1991, the state legislature sure know how to make it clear. They surely know how to make it clear that a town could have a zoning ordinance which would zone out sand and gravel mining. The legislature did not do the same thing with gas development, although it could have done it. Furthermore, there's a difference. We lawyers like to distinguish cases. You can distinguish the sand and gravel old cases from the gas cases by simply the facts. The fact that geology and natural gas doesn't stop at town lines. In order to advance the policy of the state of New York, it's unquestionable. It's going to be necessary for a gas company to ignore town lines in harvesting this resource. A lot of you know that the gas units are going to be upwards of 640 acres. The gas well may be a mile away, and you might be still within the gas drilling unit. And you can't just stop the unit arbitrarily at a town line. That would frustrate the ultimate greater recovery of gas as is set forth in the state policy. Also, that would frustrate the protection of the correlative rights of landowners, which is also in the state policy. So the underpinnings of Mr. Slotty's arguments, when you really take them apart and look at them, you can see that the support that he looks for in the mining law really is not the same, is not there for the gas development law. You know, there was a case in the state of New York called the Enviro gas case. And that's a case that was out in western New York. It was not a total prohibition against, it wasn't a moratorium on gas, but what it was a zoning ordinance under your home rule law. It was a zoning ordinance by a town which required a bond and required also a permit fee. That, the court in that case took a look at the law and said, look, this is superseded by the state law. The town can't do this. That case was appealed to the appellate division, and then the appellate division affirmed that case, and then the Court of Appeals denied the town's attempt to have it heard by the Court of Appeals. So that case is solid law in the state of New York, controlling law, which also supports the notion that a total prohibition is not going to be sustained. But you know, this preemption stuff and these lawyers making these speeches, you know, it's enough to give you a headache, a real headache. What I want to say to the town board now is let's set aside whether it's preempted or not, because that's going to be decided by the courts. Let's look at what Mr. Slidey told you about, hey, pass the moratorium now before permits are issued. You're not going to be exposing the citizens of the town of Vestal to any really significant claims. With all due respect to Mr. Slotty, when you tear that apart, when you tear that down and drill down, not to have a pun here, when you drill down, that's not the case. Let me give you a for instance, okay? You follow Mr. Slotty's advice. You pass that moratorium. No gas drilling in the town of Vestal. You have a moratorium for a year, maybe 2 years, okay? Then later this summer, all of a sudden the DEC finishes its review, which incidentally the governor said that's going to happen in a couple months, and I guess we can take the governor at his word. So the DEC finished its review, and lo and behold, there's some permits issued. So the gas companies could have gotten a permit, but they can't drill in the town of Vestal because of your moratorium. Well, a lot of you folks are aware, and if you're not aware, it's a matter of public record. Right now, unlike some other places, right now there's dozens, if not hundreds, of leases that are already signed in the town of Vestal. A lot of leases were signed in 2008, a lot were signed in 2009. A lot of these leases are going to expire over the course of the next 18 months. These leases, the gas companies invested millions of dollars in paying out bonuses and rentals for these leases. Okay, now again, let's go back to my scenario. You pass the moratorium. The DEC starts to issue permits. And then perhaps a year from now, 18 months from now, lo and behold, Mr. Slotty was wrong. The Court of Appeals determines that the moratoriums were illegal. What would you do if you were a gas company that just saw your investment in the town of Vestal go down the drain because your lease has expired and you couldn't drill because of the town moratorium? This is not one of these speculative taking cases where a gas company is trying to sue saying, I want to harvest some minerals and you're stopping me from harvesting the minerals. It's a specific damage case. It is a case that is very dangerous to the town of Vestal because they're out there. They're out there. Not only do you have a claim by the gas companies that they've lost their investment, but you're going to potentially have claim by landowners. There are landowners that signed leases that have renewal bonuses coming up within the next 18 months, where the gas company has a right to renew the lease by paying the same consideration as was originally paid at the beginning of the lease. Same situation. You have a moratorium passed, the DEC starts to issue permits, your moratorium is still in place. Later on, the gas company does not renew the landowner's lease. The landowner loses his check. Then the Court of Appeals says, oh, Mr. Slotty was wrong. These moratoriums are illegal. What do you think some of those landowners are going to do when they realize they lost their renewal bonus because of the town of Vestal passed a moratorium prohibiting gas companies from developing? It gets worse than that. This last part is not that prevalent, but there are some what we call subsurface mineral owners in the town of Vestal. You know, Mr. Slotty was saying, well, the landowners, they're going to sue, but they're going to be asking for a taking, and that's tough to get because you can use your land, even if you can't use it for gas development, well, you can use your land for farming or for recreation. You can use your land for something else. It's not the case with the subsurface mineral owners. There may be some in the room here tonight. That is where an individual or a company only owns the mineral rights. It doesn't have any surface rights. That individual, if you pass a moratorium, if that individual loses a deal because of your moratorium after permits are being issued, that's an open and shut case almost. Now, granted, there's not hundreds of folks like that, but there are that situation in the town of Vestal. So I would submit to you that you should really give some serious consideration with respect to Mr. Slotty's advice. If you wait, and the moratoriums are sustained by the highest court of the state of New York, then you can impose your moratorium without being exposed to these kind of lawsuits. And the state has already said, the DEC has already said publicly, that when the moratorium is lifted, they're not going to issue 2,000 permits. They're going to start very slowly. Probably over the first several months, there might be 10, a dozen permits issued. They said over the entire first year, they're only going to issue 75 permits. We're going to know whether these moratoriums, the Dryden case and the Middlefield case, we're going to know those results probably within the 18 months. So even if you wait, the worst case scenario is that you're only going to have to grandfather in a couple of wells. Because you'll have to grandfather them then, as your legal counsel will tell you, if the moratoriums, if the permits are issued, and if the moratoriums are upheld, you can't go back retroactively to somebody and say, oh, you got your permit, you started your drilling, well now we're going to take away that ability by passing a moratorium. So in submission, I would submit to you that when you really look closely at the law, and you look at the underpinnings of Mr. Slotty's argument, you come to the conclusion that there's drastic and significant differences between gravel and sand mining and gas development. And when you look at the stated New York State policy, you have to conclude that the state policy is to protect correlative rights and to provide for a greater ultimate recovery, and you can't do that with a prohibition. A prohibition is absolutely contrary to that, and that is why I believe that the Court of Appeals will determine that the town's ability to pass this kind of moratorium is illegal. Thank you very much. I don't know if the board members have any questions.
No, this is a Q&A, so we're ready to go.